Good day, everyone. Today, I will be discussing the matter of termination of employment. Now, in order to better understand termination of employment, it is important for us to recall one of the constitutional rights of workers, and that is the right to security of tenure. Now, under this constitutional right, which is applicable to all types of employees, whether regular or temporary, except that the application will vary as previously stated. So when it comes to project-based employees who are not regular employees, they too enjoy security of tenure, but only to the extent of the project employment contract. If an employee is engaged as a casual employee for less than a year, the right to security of tenure is enjoyed within that 1 year period. But if you are a regular employee, then your right to security of tenure is indefinite. And under that rule, no, under the Constitution, the right to security of tenure is a right that is recognized. No employee can be dismissed except for cause. Now, what is that cause? Now, take note that uh, first and foremost, it must be stated that both the employer and the employee can actually pre-terminate employment. Yes, both the employees and on the other hand, the employer may terminate employment. With respect to, before moving forward, with respect to the employees pre-terminating their services, please note that under the Constitution, uh, it would be unconstitutional to force somebody to work. In fact, that would violate the constitutional right against involuntary servitude. Now, because of this constitutional restriction, you cannot force an employee to work for you. But this is not to say that employees would no longer have any, rather, employers would no longer have any recourse against the employee. So, in other words, if, for example, training programs have been spent for the workers and the worker would later on unjustifiably just refuse to work, the employer cannot stop that. But in theory, the employer can seek corresponding damages, but they have to prove that they are entitled to it. And it would be a matter of evidence, the reasonableness of the cost of the training, the grounds why the workers no longer want to work. All of this will have to be considered, but it's going to have to be a civil action, a plain and civil action. Now, with respect to the termination by the employer or the company, it may either be actual or constructive. Now, this matter of termination, which is part of post employment, is a very important topic because this also is a part of labor relations and are often problem areas. No. Now, we go first to constructive dismissal. Now, what do you understand by constructive dismissal? Now, it is a form of dismissal, except that there is no actual direct instruction to be dismissed, and that the dismissal is in effect something that is involuntary. And as defined, constructive dismissal is an involuntary resignation resorted to when continued employment becomes impossible, unreasonable, or unlikely due to any of the following: a demotion in rank or a diminution in pay, or when a clear discrimination, insensibility, or disdain by an employer becomes unbearable to an employee. As you may note, no, the grounds here are legal, the terms are legal. So constructive dismissal would depend on the circumstance of every case. But these are more or less the guidelines. No? So if, for example, uh, you reduce the salary of the workers involuntarily, this may amount to a constructive dismissal. Let me, however, express that presently there is a labor advisory allowing the adjustment and to some extent even diminution of benefit, provided that it should not last longer than 6 months and the employees would agree. Now, if that situation is different given the present issues of the pandemic and the difficulty in the labor force. But ordinarily, if that is done indiscriminately, unilaterally, that may amount to constructive dismissal. Or if, for example, in the second scenario, you as you find ways so that the workers will be uncomfortable in the employment setup, that would not be allowed also. Or assigning the workers a work that he or she cannot accomplish, or there is difficulty, and also there is diminution of rank and rate. No, these are grounds, no, for manifestation of constructive dismissal. Now, determination on the part of the employer, or rather employee, would either be resignation or abandonment. So if the worker voluntarily resigns, then the resignation is a termination by the employee. Or if the employee himself or herself would abandon the work, that would also be considered termination. But take note that when it comes to abandonment of work, we are replete with jurisprudence that there has to be a clear showing that the intention of the worker is really to abandon the work. Because if there are circumstances that prevented him or her from reporting because she's being harassed, among other things, these things will have to be considered. And in fact, in many cases, when the workers would institute a complaint, the Supreme Court would say that that is an indication that the worker uh, does not intend to abandon the work. The fact that he or she would file a complaint. No? So it's very important to take into account the circumstances of each case. In one case, the worker even expressed her gratitude. So those things, if you express your gratitude unconditionally, then that may also be construed as an act of voluntariness. So it's very important that in both resignation or even abandonment, there's really clear showing that the intention of the worker is to really abandon the work. No? Now, the abandonment, in Tagalog, dapat malinaw ang patunay ng empleyado ay wala ng balak sa trabaho. And if it's resignation, normally this has to be in writing. There's no absolute form, no? At yun nga, walang forma. At bago aksyonan o bago tanggapin ay maaari pa itong bawiin. So it's important that there should be a meeting of the minds. No? Now, what are the rights of an illegally terminated employee? Well, first and foremost would be reinstatement. But in some cases, if reinstatement is no longer possible, instead of reinstatement, separation pay and back wages would suffice. Now, back wages and reinstatement are separate remedies, no? And of course, in some cases, if there can be damages that may be established, the award of damages. And also attorney's fees, which under the labor code should not exceed 10%. Although in those cases, separation pay was not mentioned, but take note that in a lot of decisions of the Supreme Court, when the reinstatement would no longer be possible, for example, there's no available work anymore, etc., then uh, the ruling of the court is that instead of separation pay, rather instead of reinstatement, separation pay would suffice. So the employee would be considered to have been separated, no? In which case, aside from the back wages, he or she will have to be entitled to separation pay. Now, what are the grounds for termination of employment? Now, there are basically two grounds: just causes, and this would include serious misconduct, willful disobedience, gross and habitual neglect of duty, fraud or willful breach of trust, loss of trust and confidence, commission of a crime or offense by the employee, other analogous cases. Now, take note that the terminologies used here, for instance, pertain to a serious misconduct. So it is not just a misconduct, it has to be serious. Disobedience is also a ground, but it has to be a willful disobedience, because if there is a reason why the employee opted not to abide by it, then that will be considered. Gross and habitual neglect of duty is also a ground, but it has to be gross and it has to be habitual. Also, the breach of trust, it has to be willful, among other things. No? Now, let's before we go on to the authorized causes, we're still at in just causes. Let us just expound on serious misconduct. Now, as I stated earlier, it has to be serious. Now, to be serious, it must be of a grave and aggravated character, must be in connection with the employee's work. So that's very important, because if you've committed serious misconduct at home, it has nothing to do with the work, then that may not be a ground. So it has to be in relation to the employee's work. And it must show that the employee has become unfit to continue working. So those items, please note, these are very important considerations. Now, what are examples of serious misconduct? Well, there is no hard and fast rule that a specific act would amount to serious misconduct, but there are examples that the Supreme Court decided on. For example, sexual harassment and immorality. Now, sexual harassment here would require certain elements such as moral ascendancy and the power that is to be exercised by one over the other. And there should also be some overt acts so that the workplace becomes unbearable to the employee. And immorality, there are decisions of the Supreme Court saying that when you talk of immorality, it is not something about religion, but what is universally moral. No, so those things will have to be considered. No, fighting inside workplace premises, assault against the superiors and other personnel, drunkenness, and unruly behavior. So those things. How about willful disobedience? Now, willful disobedience. In willful disobedience, there must be a clear order first. No? The order must be reasonable and lawful, sufficiently known to the employee, and it's related to the duties of the employee engaged to discharge that work, and the disobedience was intentional, characterized by a wrongful and perverse attitude. So, very clearly, the refusal is really unilateral and without basis, no, for it to be valid. Now, gross and habitual neglect of duty, the negligence should involve want of care. So, absolutely, there's no care. And under this provision, the neglect must be both gross and habitual. So if it's just a one-time error, it is not a serious disobedience. No? The other one is breach or willful breach of trust. Now, this is a very common ground But this has to be utilized only in cases where the employment involves trust. No, there must be some form of trust that management would have given to the employee. Absent any clear trust, for example, you work as a janitor. I mean, unless you can establish that the trust there is the use of the formula and all, and there is theft that was committed, that could be. But ordinarily, if there's really no clear showing that trust have been vested, breach of trust is quite difficult to prove. But aside from that, there has to be fraud, and the fraud pertains to the concealment, which involves a breach of duty, trust, or confidence, which causes injury to another, and it's committed against the employer and it's work related. Yan. Conflict of interest, falsification of documents, loss of confidence. These are examples. No? Now, aside from those, commission of a crime by the employee against the person of the employer or even an immediate employee's or employer's family or representative, of the employer. Now, the second part, aside from authorized causes, pertain to just causes. Now, I'm sorry, aside from the just causes, pertain to the authorized causes of termination. Now, these are uh, premise on what we refer to usually as management prerogative. So management, remember that under the Constitution, the right of management, expansion, and growth is equally recognized, same as termination due to authorized causes. Now, one of these is introduction of labor-saving device. So if there is a need to employ a new machinery that would cut the processes, then that may be a valid ground to separate those who are been previously engaged in a particular work that will now be taken by a labor-saving device, no? By mga computerization, etc. Or redundancy. So if the work is repetitive, then management can say that, yeah, we'll just uh, abolish your position, we'll just pay you separation pay. Retrenchment, yan. If your business is not doing well, you can go to this remedy. And of course, closure or cessation of operation of establishment. Now, this is very crucial. Why? Because if the closure of establishment is prompted by serious business reversals, there is no need for the payment of separation pay. That is the only instance where separation pay need not be paid. Of course, disease, no? But this doesn't include COVID, no? This pertain to incurable disease who can easily transmit the same. Now, this is the situation. No? Unlike separation due to just causes, when the ground is authorized cause, there has to be payment of separation pay. Now, if you read the provisions of the labor code, the payment of the corresponding separation pay is a bit a tricky part. It's a bit complicated. Why? Because it mentions there 1/2 month for every year of service or 1 month, whichever is higher. Now, do not get the impression that it will always be 1 month because 1 month is higher than 1/2 month. No, the rule is quite simple. If the employer benefited from the separation, because for instance, there's an adoption of a labor saving device or the work is redundant, basically management will benefit. Now, if that be the case, the separation pay is equivalent to 1 month for every year of service. A fraction of 6 months shall be considered 1 year. Now, in this scenario, uh, uh, the computation will have to be 1 month for every year. Why? Because the rationale is the employer benefited. Now, if the employer did not benefit because, for instance, there were losses that's being suffered, but the management naman is not at a loss, then there still should be separation paid, but it has to be only 1/2 month for every year of service, because in a way, the management did not really exactly benefit from it. Now, the tricky part there is, for example, the employment period is already 2 years, so 1/2 and 1/2 month would it be equivalent to one month salary. But suppose you only work less than 6 months, wala pang 1 year, then theoretically the separation pay should only be 1/2 month for every year of service. However, since there is a provision there that or 1 month, which ever is higher, it will have to be 1 month. So in other words, that terminology is the lowest would be 1 month. So in other words, 2 years would also be the same as 6 months, because those working for 6 months or even less will still be entitled to 1 month. Now, those who have worked for 2 years will have to be entitled for 1/2 month plus 1/2 month then. So that's the more or less the clearer picture of the payment of separation pay. So you just have to either choose 1 month or 1/2 month, depending on what I said earlier, whether or not there's benefit. No. Now, what are the distinctions between authorized and just causes? So here, these are the general the distinction. So for just causes, it's supposedly involve fault fault on the part of the employee. Pag authorized, the employee really has no choice. Now, if it's a just cause, then there has to be no payment of separation pay. But in some cases, so long as the ground is not gross misconduct, the Supreme Court considers the payment of financial assistance or separation pay premised on social justice. No? But that's on high special circumstance. Now, another important part when we talk of just causes for separation of employment is the compliance with the twin notice rule or the two notice rule. Now, ano yung two notice rule? Now, in the interest of due process, workers will also have to be allowed to respond why their services would not be separated. By the way, you don't terminate the employee, you terminate only the services. So what's that twin notice rule? Now, it is not a trial type proceedings. No? In fact, mere opportunity to explain would suffice. So this is just, number one, a notice to explain why no action shall be taken on the fault of the employee. So that's the first notice. Now, the second notice is a similar notice coming from the employer, telling the employee that despite the explanation, she or he doesn't find the same reasonable. So, in which case, it's just a notice that the worker will have to go. So, those things. No? Now, in the matter of separation, whether it's authorized or just cause, please take note that due process must be met. Now, let me just share before we conclude this that the matter of due process, when it comes to authorized and just causes, are essentially the same. The due process there is compliance with number one, procedural due process, and number two, substantive due process. Now, what is this procedural due process? Now, when it comes to um, termination due to just causes, the procedural due process here is the compliance with the two notice rule. So that is the procedure. That is the procedural due process requirement. Now, once you meet this, you can enforce determination immediately. Now, in the procedural due process, you cannot also take out the substantive due process. Now, what is the substantive due process here? The substantive due process is the existence of a ground. So the ground must really be clear. There must really be a showing that it is being exercised in good faith. So if these are established, then the twin notice rule is said to have been complied with, and in which case the worker may now be immediately effectively terminated or separated. Now, with respect to the authorized cause, there is also a need to comply with both procedural and substantive due process. It also has its procedural due process and substantive due process. What are those? The procedural due process for grounds based on authorized causes pertains to the written notice to the employee concerned and the dole, which the law mandates to be given at least 30 days. So why 30 days? Well, simply to allow the workers to still find the work, no? And during those time, he or she should be paid the corresponding salary. Now, aside from the notice to the employees and the dole. So there's a separate form that you can download from the website of the Department of Labor, and you fill in the blanks stating the name of the workers to be separated, and you submit this to dole. That's one procedural due process. And the second procedural due process is that the effectivity of the separation or severance must be made 30 days from that particular notice. So, if there is a violation of this procedural due process, even if the ground is authorized cause, then the uh, separation would be considered supposedly as illegal because absence of procedural and or substantive due process makes the dismissal illegal, no? Supposedly. But later on, I will explain that under recent jurisprudence, the Supreme Court held that the separation based on authorized cause which failed to meet the procedural due process um, may not exactly uh, render the entire dismissal illegal, no? But merely ineffectual. Now, if there is no ground, or if it is the substantive ground, on the other hand, that is wanting or that is missing, then that makes the dismissal illegal. Now, what is the lack of substantive ground when it comes to authorized cause? No? If, for example, there's really no retrenchment to speak of because after you've separated the worker, you've hired additional ones. So that may be considered as separating the workers in bad faith. So there's really no ground. You just made use of the process to sever the employment tie, then in which case the dismissal would be considered illegal. So take note of those things before you will have to consider separating workers. Now, in our jurisdiction, the law is quite clear and also very strict that separation of of the employment would clearly be fatal. No? Now, in some cases, when there is mere violation of the procedural due process, the dismissal may be considered ineffectual, and when the decision becomes final, as and by way of penalty, there may be a corresponding payment of the back wages, but the back wages stops when the decision becomes final. There will be no more subsequent separation pay. That would be the most justifiable way to to consider the rules on separation of employment. Now, take note that the matter of exercising these rights, no, in the Philippines, no, requires proper guidance. So it is not something that should be abused, no. And sometimes the problem is because of procedural lapses. Many employers would end up paying erring employees. So it is important in this light that if and when you become part of management, no, it's very important that there is a proper system that is in place wherein an erring employee's this malperformance should be documented. So it pays to have everything documented, and that these documentations be part of the 201 file of the employee. Why? Because at some point, as I said, it's not also enough that workers would always insist on their right, etc. For every right comes great responsibility. So as an employee, you also have this concomitant obligation to organize your work and to work properly. Absent any proper guidance or proper way of working, then it could be a problem. No? So one has to really consider his functions, no? And the duties that come with it. And for the employer, they really have to document everything so that at some future time, when this worker would again similarly commit the same violation, management would be ready to address it. Otherwise, past mistakes that are undocumented may not be invoked at all because it would violate the right of these workers to due process. They have to know. So if you did not tell them in effect, you do not have documentation to that effect, then that would be a serious concern because in the end, the worker, or rather the employer, might even end up paying for the employee. So that is why this is very important. No? So compliance with both procedural and substantive due process are very, very important. Absent any of those, it will affect the employment. So that wraps up a brief discussion on the termination of employment. Thank you very much. Have a good day.